Hi, folks. Denise Howell here. And next up on This Week in Law, we've got all kinds of cats. Nyan, Keyboard, Fishing, and Venkat Balasubramani to be exact, along with Sarah Hawkins, Evan Brown, and me. We're going to talk about Bitcoin, PadMapper, Instagram. You can be tagged now. Lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Evan Brown and Denise Howell, episode 209, recorded May 3rd, 2013. Cat Meme Fever. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter Twill. Hello there. I am Denise Howell, and you're joining us for This Week in Law, where we talk about all the exciting developments at the convergence of the worlds of technology and the law. We do this every week, and we have fabulous panels of folks who come and give us their insights, and today is no exception. We've got, returning to the show, Venkat Balasubramani, who writes very frequently at Eric Goldman's technology and marketing blog. Hello, Venkat.
Hi there. Thanks for having me, Denise and Evan.
It's wonderful to have you back on the show. Lots to go through with you today. Lots of very interesting topics, both on your blog and elsewhere. That you've highlighted for us. So we can't wait to get to those, but we do want to introduce our other panelist today is Sarah Hawkins from Saving for Someday. Hi, Sarah.
Hi, Denise. Thanks for having me.
It's wonderful to have you. Now, I found Sarah because I was doing some legal research online, and she had written a series of great articles that were right on point for me. So Sarah is a lawyer and does all kinds of wonderful things. If you're wondering, if you ever wanted to meet a lawyer who can save you money, that's Sarah, which is a great thing, not often associated with our profession. Sarah has great tips and tricks on saving money on her blog and a wonderful series on blog law. So we'll talk more about that later as well. Great to meet you, Sarah.
Nice to meet you. Thank you.
And joining us from Chicago, Illinois, is Evan Brown. Hello, Evan.
Hi, Denise. Happy Friday to you. I hope everything's going well. This should be a great conversation. Always good to catch up on these things. Best part of the week, don't you think?
It is. It's always the best part of the week. So let's start out with one of our favorite topics. Lots of things going on involving copyright. So there is a game company that is called Greenheart Games. I think it might be based in Australia. And its founder is named Patrick Klug. And they have a game called Game Dev Tycoon. And for all you law professors out there who listen to the show, you're going to want to pay attention to this if you haven't already heard about it. You probably have, because they really made a splash this week when they released their game. Because not only did they make the game available for purchase, but they seeded a version of the game. Patrick did this himself, I think, on BitTorrent. And the difference between the purchasable game and the BitTorrent game played along just like the regular game for a little while. And then it turned out that the folks, it's a wonderful concept for a game, by the way. Game Dev Tycoon, as you might gather from the title, is you get to develop and sell games in, a virtual environment. So it sounds super cool. It sounds like something that my son might love, actually. So I'm going to check it out. Anyway, so the folks are playing along in the game, being their tycoon selves, and all of a sudden, their games start getting pirated in the game, and it's hurting them in the game. And folks are going on, and it only happened, of course, in the version that went out as a cracked version on BitTorrent that, masqueraded as an unauthorized version of the game. So folks, rather than getting that they had been had, went on to message boards and forums trying to figure out, hey, I keep getting pirated. What's going to happen? How do I fix this? And the point that the game developers were trying to make is that you shouldn't pirate games because it hurts the developers. So very humorous, wonderful opportunity for those law schools that are still in session. I know that many have already taken their law school finals, but for those IP law professors out there to consider all of the copyright ramifications of putting a supposedly cracked version of the game on BitTorrent to prove a point. Now, over at Ars Technica, I think he is the games editor there, Kyle Orland, thought this was fascinating, got together with all of their editors and their commenters over there when this first broke, thought this was very fascinating too, and were posing all kinds of great questions and scenarios, primarily around the implied license to the supposedly cracked game, since that was put up voluntarily. If you didn't mind being pirated and you wanted to continue playing that game, and could do so, would you actually have a right to do that because of the way that it was put on BitTorrent? And a whole bunch of other issues, were these guys, suppose they were sued for copyright infringement by the game developers, Greenheart, would they be liable for damages? Could they say that there was an implied license? Does it make a difference that they were sort of suckered into downloading this? And Evan and I both talked with Kyle, and he has a good write-up on it over at Ars Technica. And we both kind of took different positions on what might happen on the damages front, didn't we, Evan?
Yeah, and that was interesting reading that article, because I saw that you were quoted in it too, and I felt like I was like, whoa, Denise is here too. It's like showing up at some random cocktail party and you being there as well. So
it was.
I was like, hey, I know her. So, yeah, this like you said, Denise, you hit the nail right on the head, saying that this would be a great hypothetical for a law school exam, because it does. I think you could really spin these facts completely different ways to come up with different results, and the advocates on either side would have some pretty good places for footholds in these types of arguments here, because it is weird. We have a situation where it's actually the copyright holder who has put this out there, promoting it, marketing it, and I'm using air quotes, as a cracked version. So it's essentially saying, with a different voice, hey, this is a pirated version. Go ahead and pirate this. And so then the real question becomes whether or not it's unauthorized for people to continue to distribute this using BitTorrent, and to use it and to continue to distribute it using the BitTorrent protocol. So I think you and I both recognize that the essential issue, or at least a threshold issue, is whether or not there is an implied license here. One of the most well-known cases dealing with an implied copyright license comes from out there in the Ninth Circuit. I think it was from the early 90s, called Effects Associates versus Cohen, and that tells us pretty clearly that a copyright license can be granted through mere conduct. It doesn't have to be in writing. The Copyright Act contains some statute of frauds type of language for when it comes to copyright assignments, where an assignment actually has to be in writing, but a copyright license doesn't have to be in writing, and in fact, it doesn't even have to be spoken about. It can just be done through the conduct of the parties. So we look at the intentions of the parties and all that stuff, and so here it's there's something strange. Well, it's not necessarily strange. I mean, it's no mystery what happened, but it's a bit odd, a bit out of the ordinary for the copyright holder to actually put the work out there with the intention, presumably, that people will pick up on it. Though I think the real intention is for people to see this message about anti-piracy. So lots of different ways that you could spin this in discussion. If there were actually a lawsuit about this, which we're pretty clear there's not going to be, the game developer saying there's not, or lots of ways to talk about in a hypothetical environment, laboratory, like what we have here on the show, or in a law school exam, something like that.
So Venkat, if Evan is right, and there could be an implied license, and I think he's right, and I think that there probably would be if you're putting something out there and expecting people to download it. Do you think it makes a difference that the vehicle they used was BitTorrent? Does that change the scope of the license and perhaps imply a broader redistribution than, say, they had just put a file on a web page and said, download this?
That is a great point. I think I can see making that argument. The flip side might be, do people really go to BitTorrent looking at what percentage of the files do they view as legitimate or authorized? And if I just go to BitTorrent, if somebody puts a file on there, is that enough to say, okay, this is an authorized copy? But I agree with you. I think putting it on BitTorrent, pretty much you do so knowing it's going to be widely distributed, and you would have a tough time bringing an argument against downstream distributors or people who further distributed the file that they were somehow unauthorized in doing so.
And then, Evan, you thought the entrapment, quote unquote entrapment, I mean, entrapment is really a criminal law concept and doesn't really come into play with copyright infringement. But my gut reaction to it was that it would have to factor into the damages somehow. And your thought was it would probably aggravate the damages because the people downloading clearly thought they were downloading a cracked version. And meanwhile, I feel like they should be given some kind of a break because they were kind of lured into this. But it's sort of, angels dancing on a head of a pin. You wouldn't know which way it would cut until a judge actually considered it. Sarah, do you have a guess?
Go ahead.
Sorry.
Well, it's one of those situations where, they're already kind of, they would already do this, and they already do this on a daily basis, multiple times a day. So it's not, I don't see the entrapment part of it, like you said, on the criminal side of it issue, but I don't see that you're enticing them to do something that they would not normally do. And so, I don't know if they should actually get a break, because if they're kind of too dumb to realize they shouldn't come forward and complain about this, then they kind of get that Darwin tax effect of the fine or what have you. So they're in a situation where they're kind of, a catch-22, and they should just sit at their computer and just keep downloading more stuff and be quiet.
Right. It's a pretty hefty Darwin tax, though, that you're talking about under copyright law, where if willful infringement is shown, it's up to $150,000 per infringement. Evan, what were you going to say?
Well, what I was going to say is different than what I'll say right now. I mean, the intention of the game developer is what goes into the question of whether there's an implied license, but it's the intention of the user that would go into this damages calculation that you're talking about here now. And clearly, the intention of the game developer was to distribute this work so that the message, the anti-piracy message, could be distributed. But that's, there's no way that the user could have known when it selected that torrent to acquire that's what the game developer's intention was. So if we look at the damages calculation, if liability were proven and we then go to the damages phase, and for there to be really jacked up statutory damages all the way up to $150,000, you look at the question of willfulness, which is in turn an examination of human volition and what the intention of that party was. And it seems to be some pretty black and white facts, some very clear facts, that the intention of the user, acquirer, distributor, however you talk about a BitTorrent user, was to acquire a copy that was purloined because of the, in all caps, it said the word cracked on it. So that would go, play very well into the question of damages. And that's why I guess this is, I think, what I was going to say earlier. That may be why I would want to have a conversation with you a little bit more, why you think that the user should get a break. I would ask you whether you're conflating the intention of the developer in distributing it with the analysis of the intention of the user, because, gosh, the user's intentions are pretty clear here. Hey, give me pirated content, and I don't know why that should be entitled to a break.
Yeah, you're right about that. I guess what I'm doing is bringing over sort of that concept of criminal law entrapment. And Scott Michaud in IRC is pointing out that to the extent the DMCA would come into play here, we are talking about criminal penalties. So perhaps entrapment might become more relevant. But yeah, it just seems to me if someone is honeypotted into doing something, you have to kind of treat their actions with a bit more generosity.
Right?
Yeah. Not so much with the sweetness. What do you think about the DMCA's role here, Venkat?
I don't see it as, I guess it protects the intermediary, but I don't know to what extent it really helps the claim against an end user if the developer were to bring a claim.
But how about the whole cracking aspect of it, the circumvention part?
Well, there's nothing really being circumvented, right? There's no copy control mechanism that I think the claim against an end user would be tough because it's not, it would be interesting if the developer made a version available and then separately somehow seeded a website and said, okay, here's a bunch of keys you can use. They're not authorized or something like that. Maybe there's a claim for circumvention, anti-circumvention. But outside of that, if it's just a version that you download and play, I don't know how the developer could raise the DMCA issue against end user. One point I was going to mention to you. Oh, go ahead, Evan.
No. Well, just let me interject. Because at that point, the circumvention would have already been committed, the purported circumvention. Right. Yeah, that's all.
And one point I was going to ask as well is, was there a splash screen or something that said, make sure your copies are authorized. Here's how much it costs to buy one. We hope you didn't download this. That might have been an interesting way for the developer to try to neutralize the entrapment type argument or defense to say, sure, you obtained it from somewhere and we made it available, but once you downloaded it and turned it on and started playing it, you knew you had gotten it from somewhere that was not authorized.
I don't believe they did that. And folks in IRC, if I'm wrong, let me know. But the coverage that I haven't actually played through the game, the cracked quote unquote version of the game. But apparently what it did was kick in certain features that would make, just because of the nature of this game, how many other opportunities would you have to do this? But the person playing is playing the part of a game developer. So what would happen was things would start to come in, maybe make the game even more realistic than the authorized game is, that piracy is a factor here and it's going to hinder your gameplay.
Right.
So I think it just, was a penalty that came in that they coded in, which was brilliant. Very interesting approach toward sending the message to their user base. And then the numbers were pretty alarming. They had a few hundred or maybe less than 300 people actually purchase the game, but over 3,000 got their hands on the BitTorrent quote unquote cracked version. So that's pretty staggering. Of course, not all those people might have purchased the game. I don't, we get back to that question of, is piracy really lost sales? They might have sold just the same amount and probably would have sold just the same amount if this cracked version wasn't out there. And maybe, who knows how many copies of the game and probably quite a few, the actual authorized game, are out there being pirated around now to prove the opposite point, from the user's standpoint. So very, very interesting little scenario that played out there. Let's move on, though, to some different kinds of copyright allegations. Craigslist has not been huge fans of people who want to use their data for other services. And this is not the first time they've sued. They sued a company called PadMapper here, though, that was locationally organizing Craigslist data. So it would take the data and put it on a map so you could see different apartments of different sizes in different locations, and then, use Craigslist in the way that it's intended. So Craigslist sued, saying that this was unauthorized use of the data in Craigslist, and asserted that it had the copyright to all the user data, not just a license to use that data, but the actual copyright, and could sue on its own behalf to enforce that copyright. That claim got thrown out. There is no such copyright, because all that Craigslist had given itself was, as many, many sites do that use user content, a non-exclusive license in the material that users submitted. So its copyright argument here against PadMapper did not fly at all. Evan, this kind of reminds me of the cases that we used to see a while ago involving trespass to chattels. There are certain people who are authorized for indexing purposes, to scrape and copy material from the Craigslist site, but third-party developers like PadMapper are not in that category. But it doesn't seem like we see that trespass to chattels claim much anymore. I think it's just become perhaps too difficult to prove. Do you agree?
Well, I suppose so. There's the well-known case out of California called Intel versus Hamidi. That's one of the leading cases when it comes to trespass to chattel. When you're doing something to somebody else's computer, and usually the facts are going to be a lot like what there is with an alleged or purported Computer Fraud and Abuse Act claim, accessing or doing something to the computer that causes some kind of diminution in the performance of that computer or something like that. So really, I don't see why you couldn't go ahead and allege trespass to chattel in a lot of situations, especially if it's implicating the performance of the system, like a DDoS type effect. There was another case called eBay versus Bidder's Edge, kind of had some similar effect. That was one of the early kind of scraping cases. I think that was actually in the 90s at some point, or in the early part of the last decade. But this is an issue that's here, and there's so many startups and ongoing enterprises that use the type of approach, of going and crawling the web, the open web for data. If there's not an open API, taking Craigslist data or Pinterest images. Well, oh wait, maybe that's kind of what Pinterest is doing, but just through its users, or Instagram photos, combining them and repurposing them in some way. And so there's a whole host of issues that come up in situations like this. Breach of contract. Most commercial sites have prohibitions on automated access to the system. Computer Fraud and Abuse Act is there. Breach of or infringement of copyright. So we see this. Oh, and also, of course, trespass to chattels, like you were talking about. So we see these technologies and this notion of doing something like this as a business model among a lot of startups, and the legal issues that arise from it are problematic. And with this situation here, that the copyright infringement claim, that's problematic because of what the terms of service said. And then on the breach of contract claim, there's a little bit of humor that goes into this, and Derek Canna in that Forbes piece that he wrote in the last week or so about this, really underscored some of the silliness in the liquidated damages claims under the breach of contract theory here. The Craigslist terms of service, I don't know if it still says this, but it's like it calls for liquidated damages of $25,000 for every unauthorized crawl of the site. And if you average that out and just kind of try to do some reckoning, figure out what that is, it's something like, what was it? Some like $32 trillion or something. I mean, just like, some
9,125 trillion per day.
Wow. I was off by a few orders of magnitude then, wasn't I? I mean, isn't that more money than even exists in all the gross domestic products of all the countries on the face of the earth?
I think so.
So,
pretty good guess that it is.
So you Craigslist would have a hard time saying that that's not a prohibited form of liquidated damages, because the contract law says that liquidated damages are not supposed to serve as a penalty, but to somehow represent the actual harm that would have been suffered if you could prove it, if you could actually articulate what that harm is. So the law is kind of all over the place here, or at least the issues kind of are all over the place here, coming from different directions, and but it's something that needs some attention because of the way that business models like this work.
Yeah. Hey, Venkat, in Derek's article, he did some of what we indulged in last week on the show, sort of our wish list for the House Judiciary Committee as they hold hearings and consider wholesale revisions to copyright law. Derek, in writing this article, said if people are going to assert copyright infringement on such tenuous grounds when they clearly don't have the copyright at all, that should be punished. There should be some concept of copy fraud or copyright misuse where they would be penalized for having done that. Do you think that's a good idea or a bad idea?
I think in general, having plaintiffs who bring copyright claims and lose them shoulder some of the burden and get tagged with fees is a good idea, just because I think that right now the Copyright Act authorizes damages or attorney's fees against a losing plaintiff, but it's in the judge's discretion. And I think Vimeo is a good example of a case, or Veo, I forget, that copyright claims lost, but ultimately bankrupted the company. And I think the Ninth Circuit affirmed the district judge's refusal to award fees. So I agree that some amount of incentive on the part of plaintiffs to make sure they have credible claims is a good idea, and fees are a good route to that. One quick disclaimer: I actually represent PadMapper in this lawsuit. So
I did not know that. Congratulations. Coming back to your point about the Computer Fraud and Abuse Act and the copyright claims. So the copyright claims, the way they were resolved were kind of interesting. Craigslist had this confirmation screen for a short time period, for like 5 weeks or something like that, where end users said, you confirm, by submitting a post that you grant exclusive rights to Craigslist, but they only had that screen there for a short period of time. And the default language in Craigslist terms of use said you grant Craigslist all rights, and didn't use the word exclusivity. And the court said that language is not sufficient to grant exclusive rights. So the time period where there was a confirmation screen, Craigslist owns the individual listings, but where there was no confirmation screen, the terms of service was not sufficient to convey rights in the individual listings. That said, the court did say that Craigslist has copyrights in the compilation of the entirety of the database, the aggregate listings, and so that part of the copyright claim goes forward. And coming back to your trespass point, the Craigslist did not assert trespass claims against PadMapper, but they were against 3Taps. The court allowed the Computer Fraud and Abuse Act claims to go forward, but had this kind of lengthy footnote that said, I'm a little bit concerned about the implications for letting an entity use the Computer Fraud and Abuse Act and the terms of service to basically block access to publicly available data. The data is available to end users, obviously, and through Google. And I think the judge rightly expressed some concerns that, where are we at policy-wise, to the extent that somebody could use a criminal statute to block, to bring a Computer Fraud and Abuse Act claim. And the narrow basis that he allowed the claim to go forward was to say that Craigslist had sent 3Taps a cease and desist letter and had used some IP address blocking. And the court said, after that point, any access beyond that is enough to support a Computer Fraud and Abuse Act violation. So a really interesting ruling, I thought, and the copyright ownership
part of it is definitely one that could have some implications to other websites and other terms of service that typically do have language saying that rights in the content may be conveyed to the website or the platform. So that's my 2 cents.
It's fascinating, and I'm really glad you shared your insights, having been involved with the case. Sarah, my sort of, without taking a comprehensive review of every user site terms of service out there, my general impression is that sites don't try and have users assign exclusive copyrights, and that there would be a wholesale revolt if we were to see people take this, companies take this Craigslist ruling to heart and start slipping that language into their terms of service. Do you agree with me?
I do. I think that we actually saw this with Instagram when Instagram tried to change their terms of service and kind of slipped that language in there that it's not the license for them to redistribute your uploaded photo. Basically, they could then take your photo and sell it. And I think this was a question that came up early on with Pinterest before Pinterest rewrote their terms of service as well. And they're actually still out there, a number of discussions of people who took down their pin boards because of that, because after reading somebody's take on what the interpretation is of the Pinterest terms of service, they didn't realize that that's what Pinterest was asking them to do. So, two of, the largest platforms recently kind of attempted to do that. And there are plenty of people like Venkat and I who sit down and actually read these things and then write about it. So that's the problem, that people are out there reading this stuff. And while not everyone is an attorney interpreting them, there are plenty of very technical people who will let everybody know that you're giving up you're giving up your copyright, and we just haven't been educated that that's what we're supposed to be doing with this. And if that's what they want us to do, then at least be upfront about it.
Yeah, we've seen that time and time again where terms of service get scrutinized, and what I sort of feel usually happens is the terms of service aren't as draconian as people reviewing them might believe, and there's a freak out, and then it turns out that really the terms let the site use your data in ways that make the site functional and useful for you, and so it's all good. But when we start talking about transferring exclusive copyrights to third parties, that's a whole different ball of wax. Venkat, do you know if Craigslist ever came under fire for that before this lawsuit?
Well, yeah, absolutely. They did. And they, after they implemented their confirmation screen, I think the EFF did a blog post that said, hey, what are you doing here, Craigslist? And I think in response to that, they backed off. And oddly, in the lawsuit, they continue to take the position that they have exclusive rights in the listings, but there was definitely some public back and forth on that issue.
See, isn't there just something really odd about this being a copyright question at all? If we take it all the way back to the fundamental level of this, and what copyright's all about, the fact that Craigslist is claiming copyright in listings. I mean, a Craigslist listing. I mean, yeah, there are a few kind of pieces of art that are Craigslist listing, like the three, what was it? A couple of girls, I think it was just this past New Year's Eve, put up this really well-written ad about finding a guy just to be their boyfriends for New Year's Eve. And it was just, very, very funny, a Craigslist post. And occasionally you'll see that certain Craigslist posts show up that are really well. But, most of them are like, hey, I got a couch, $300. Send me an email, you can come look at it. Is that something that should even be, even begin to come under the auspices of copyright? And, so yeah, if it is, then, it just seems like copyright's playing in a weird environment here, playing a strange role, kind of being, I don't know. It's just odd.
Did you raise that, Venkat, as a defense?
No, we didn't, and but I think that's definitely something that could come up. And you're right. I think the basic facts in a typical Craigslist listing, you have this apartment, here's the price, and et cetera, I think are tough to say are copyrightable. And I think you raise a good point, and I think the way the court resolved it in general, definitely Craigslist is pushing the envelope with respect to its copyright claim and its Computer Fraud and Abuse Act claim. I think they're arguing for a very robust interpretation of both those statutes. So I agree with you, Evan. I think it is kind of strange to see that. I mean, it almost kind of also reminds me a little bit of like very different context, but medical justice, or there was scenarios where doctors try to get copyright to reviews to get them taken down. I mean, the typical end user would just be like, what are we, kind of scratching their heads saying, wow, I submit a listing to Craigslist and Craigslist now says they own the copyright to it. I think it's very contrary to the typical end user expectation.
Right.
All right, well, let's make copy fraud our first MCLE passphrase for this episode of This Week in Law. If you're a lawyer interested in getting MCLE credit in your jurisdiction, we've got some information for you up on the TWIT wiki. And if you're in other professions too, I know we've had some non-lawyers using the show for professional credit as well. So if you need to demonstrate that you've actually listened to the show, our first word for this show is copy fraud. Okay, so before we leave the subject of copyright, Sarah, you put in an interesting article, just an assessment that was done by the U.S. Trade Representative as to which country is the worst copyright offender in the world and who's on the top 10 list. And this year, the Ukraine wins. And just a funny little blurb over on Yahoo News that intellectual property is so loosely regarded in the Ukraine that there's no clear system for collecting royalties. Its governmental agencies use pirated software, and there's no effective system to combat online piracy. So there you go. Ukraine takes the crown. And also on the list is we've got a heavy emphasis on Asia and South America here. We've got Russia for the 17th year, Algeria, Argentina, Chile, China, India, Indonesia, Pakistan, Thailand, and Venezuela. Anything else you wanted to add to this, Sarah?
I think that there's some commonalities among all of them, and their general lack of regard for the rights of other people, not just with the intellectual property. But like I said, it wasn't surprising. It was just actually very funny. And I'm sure that a couple of these countries are probably upset that they aren't, the world dominators in hooliganism.
Right. And the upshot of this is if you're, this bad of an actor on the global scale, you lose trade privileges with the U.S. and other countries.
Right.
So,
but the thing is that a lot of our websites, the problem is that you have your own personal website. I have mine. We all do, and our problems are that people in these other countries will start taking our information and putting them up on sites, and basically link baiting them for ads and various things like that. And that's what kind of is the bummer, is that you work really hard to create some good content and it shows up in other places just so that they can, get ad revenue.
Right. And then Google and others just add to their tens of millions of DMCA takedown requests they receive and process each week as
exactly.
they try and, get rid of the links to all that stuff. Venkat, any thoughts on this?
Yeah, I think it's. This is anecdotal, but I'm somewhat surprised to not see Spain on that list. Again, anecdotal, but I've talked in traveling in Spain and seeing a bunch of people over there. It's amazing how common downloading. It's almost like it's not even viewed as illegal. You talked about BitTorrent. I probably talked to 5 to 10 people who are like, yeah, I download stuff. Of course it's legal, But another interesting note is that I'm curious about India and China to a certain extent, to the extent those countries start producing IP that are valuable to them, whether the industries locally, whether it's Bollywood or programmers locally would kind of say, hey, let's try to change the mentality and instill some better respect for IP laws in these local countries. And I'm curious as to whether that might happen over time.
Maybe they'll start seeding hobbled games on BitTorrent as they put them out. Evan, anything on this before we move on?
Just a couple things. I mean, where is Antigua in this discussion? Weren't they the ones that were supposed to be doing?
Yes.
Like we're saying, we're just throwing this all to hell. We're going to just be the worst,
right?
And then the other thing is, I was thinking, on Sarah's comments, this stuff shows up, and shows up in search engines and can generate revenue for paid, running paid ads against it and all that stuff. If I remember correctly, didn't Google implement some new policy in the last year or so where it was going to take the number of DMCA complaints against a site in factoring in its page rank? Maybe I just dreamt that, but there's something that good, because that would seem to be a good thing to combat this phenomenon of pirated. Of content. Man, I don't want to use the word piracy in this context, but copied content, on a foreign website. So what if it's out there, if it's not showing up all that well because of its low page rank? That's Google is kind of taking care of us in that respect. So those are the couple of observations I had on this.
All right. Well, let us take a break here. Thank our sponsor for this episode of This Week in Law, which is ShareFile. It's not only what we do at work, but how we do it that makes the difference. Our flow of information needs to be ongoing, collaborative, and time efficient, whether we're working at the office or on the go. And ShareFile helps you do all that easily and securely. ShareFile by Citrix seamlessly integrates into your daily routine, no matter where you are, from any mobile device. With ShareFile, files of almost any size are sent as secure links. Notifications are sent to you once they're opened to track their progress. Files can be password protected for ultimate control. And having access to your files from any device like this and having it in a way that works so seamlessly with your other online life is just very invaluable for you as a business. I'm a solo practitioner. Sarah's a solo practitioner. If you have a small business that you're managing yourself and you need to move files around, I just can't think of a better solution than ShareFile, because it basically serves as my extranet for clients. It enables them to get at any large files that I need to share with them. I don't need to worry about whether an attachment to an email is going to get caught either on my end or on their end and not get through. They're going to get it. And when I'm communicating with a party that I maybe have not the friendliest of relationships with, maybe someone on the other side of a lawsuit or dispute, I can see what they've read and when they've read it, which is important information in the legal profession and in others. You can set up shared folders for easy collaboration with clients and coworkers. Makes it super easy just to get your stuff done. Very fast and simple. ShareFile will change the way you work. To help you get started, I have a special 30-day free trial offer with no obligation, and you'll see the difference right away. To get that offer, go to sharefile.com today, click on the microphone at the top of the homepage, and enter TWIL, T-W-I-L. That's sharefile.com, and type in TWIL. Thank you so much, ShareFile, for your support of This Week in Law. Let's look at a couple of entertainment stories. Venkat, when there's a story that involves Nyan Cat, Keyboard Cat, and copyright infringement, I don't know how we don't talk about it on the show. Why don't you tell us what happened here?
So a lawsuit was filed a copyright and trademark lawsuit was filed against Warner Brothers and a game developer called Fifth Cell Media, alleging that a game that Warner Brothers distributed or sold or whatever violated the trademark and copyrights of these two individuals who claimed to own. It was unclear exactly what parts of the meme they owned, but they essentially said that they own different parts of Keyboard Cat or Nyan Cat, which are both popular, or which is a popular meme that I guess is one of the most viewed videos as rated by Current TV.
Right. So how could someone as big as Warner think that they could just appropriate these very well-known, iconic memes and stick them into a commercially available video game? What's going on there?
Well, I think it's a really interesting lawsuit, I think that ownership in memes is a very interesting topic overall. And as this particular lawsuit illustrates, it's never really clear who owns what. And I think it's not even clear whether they even own what they say they own, because they're taking it's a mashup essentially, and they're taking art, music, and different elements from elsewhere and combining them. And so I guess as a threshold matter, it's not easy to say, okay, here's a meme and here's who owns what in the meme. And I sense plaintiffs may have some challenges along those lines. And another issue is that I think the internet plays a big part in commercialization of the meme. I mean, the meme wouldn't necessarily be popular or valuable if people would not have taken it and spread it and retweeted it or posted it or propagated it. And so it's somewhat awkward for somebody to come along and say, okay, we're the ones who can now commercialize it, even though, without the kind of collective culture that made it popular in the first place, it may not be worth anything. So I think that it's an interesting lawsuit from that standpoint. I'm not saying it's totally meritless, but I think it'll be interesting to see what defenses Warner Brothers raises and this game developer raises as well.
So, Evan, it seems like for many, many years now, we've heard people creating works bemoan the fact that it's hard to get a license from people like Warner Brothers if they want to use something of theirs in, a mashup or anything else. So clearly it would be difficult to get a license if you're not certain who owned or created all of the aspects of something like Nyan Cat. But should that be an excuse?
I mean, if the tables were turned and if you took any one little sliver of, something from a Warner Brothers movie and tried to incorporate it into your meme, chances are good that they would come after you very aggressively. So it would be quite interesting, for the plaintiffs to either raise Warner's own arguments that they've raised in other cases, or take something of Warner's and kind of take the game and incorporate it and do another mashup on the meme and see what happens. So you raise a great point. I think if the tables were turned, I think Warner Brothers would be very aggressive in their enforcement of anyone else who's incorporating even a sliver of their content.
All right, Evan, I fired that question at you, but we dropped you there. Do you have any thoughts on Nyan Cat and Keyboard Cat showing up in this game? I know that at least at Christmas time, there was a big push around the Wii U that this was one of the few games that was available for it. They appear in the Scribblenauts game. So I don't know how many copies have sold since then, but it definitely was getting marketed heavily.
Sure. Well, everything that Venkat said, that's what I would say about all this. And I guess one kind of weird thing I would see on this, it sounds like it's going to be an interesting damages calculation for this. You wonder how protective the original creators of artwork that turn out to be memes are of their content. And the analysis goes in to look at how much it was appropriated by Warner Brothers. And, if we're going to operate from the starting point that they're just going to be looking for actual damages, I think it's probably safe to assume that there may not have been, I don't know if it's safe to assume that or not. It's usually a question of whether or not statutory damages are going to be available in a situation like this. So, like I said, everything that Venkat said was very smart, and so I would just subscribe to what he said, and then look at add that damages question issue into the discussion as well.
Yes, it's always smart. Shall we just second Venkat and move on? Sarah, do you have anything to add?
Well, I just want to say that Warner Brothers has actually sued people. It's called the MPAA and the RIAA through Warner Music. They kind of do go after people very heavily. There have been a couple very large cases where, they've been quite protective of their own intellectual property. But I think here, I'm looking forward to this to actually kind of go through and not be settled, because I'd like to see if they raise the parody claim and try to get this under fair use, because that's, I think when it comes to memes, that's a big issue. That if you do a DMCA counterclaim and say that it's fair use, then a lot of times the administrators will just drop and leave the work up, because they're not going to deal with trying to figure out if it's fair use or not. So that would be interesting.
I haven't looked at the game. Have you? Is this in your family's collection?
No. But it'd be interesting the concept of a meme. I mean, first off, I'd like to be there when lawyers tried to explain to tech-challenged judges what a meme is, and first get the judge to say meme incorrectly. I think that'd be actually very funny.
Like meme.
To sit there and listen to a judge, the meme and the meme, like a bad SNL skit.
That's funny.
Well, wasn't it Eric that pointed out, Venkat, that he thinks that catfishing first appeared in a legal decision in a case that you guys wrote up?
That's right. Yep, he did point that out.
Why don't we go ahead and talk about that now, since it's just a weird and strange and funny case. I love Venkat. You're great at finding graphics to put on your blog posts, and you have a catfish cooking catfish.
That makes me so happy to hear you say that, because I do put some effort into it, and I wonder if it's totally wasted and people are like, oh, who cares, So that's excellent.
You always attach something entertaining. This was a couple of really mean dudes at Ball State University, just ganging up on their poor roommate and then ex-roommate and doing awful things to him, leaving food in his room to spoil so that it just became uninhabitable in there. And then catfishing him, which again, the court was familiar enough with the word to use it in its decision. This was educational for me, that the process of setting up a fake Facebook or other social media account and trying to have a relationship with someone, convince someone that they're actually having a relationship with that account, whether they're a football player or a poor forlorn teen, or in this case, a college student who thought he was showing up to meet a young lady, I believe it was, and it turned out to be his terrorizing roommates, who then videoed the whole thing and put it up on YouTube. And they wound up getting kind of slapped on the wrist. They got disciplined by the university. They tried, the interesting part of this, and I guess this is why you guys wrote it up, Venkat, is they actually sued and tried to make a First Amendment argument that they're documenting their poor behavior was expression, and that didn't get them anywhere. So why don't you take it from here on this, Venkat?
Well, I think you described it perfectly, and I thought the consequences to the students were fairly harsh from the standpoint that I think they were both suspended for a year, some amount of time, and I would imagine as a college student that's somewhat significant. And one of them ended up just going to a different university altogether and continuing elsewhere. I think their First Amendment claims were a challenge. I think speech codes at universities often lend themselves to kind of squelching speech, but in this situation, it was a real stretch, and there was a privacy argument, and that they had done some other things like leave a sandwich in the roommate's door and locked it so it was rotting, and when the roommate came back after vacation, he couldn't enter into his room. So, it was an interesting and messy case, and I thought that the students who were suspended had a pretty tough First Amendment argument to make, but I guess it's a good cautionary tale that don't catfish your roommates or others.
Yeah, definitely that. Evan, any thoughts?
Well, I went to college in Indiana, and Ball State is in Indiana, so I cannot say that these guys weren't drinking a lot. You know that firsthand. Ball State kind of has a reputation as a party school, and I'm sure that if anybody, in IRC or anybody listening is, hearing that, you wouldn't disagree. So, I think the penalty was pretty harsh. Getting suspended for a whole year, and that's kind of a big deal, and. It sounds like maybe if the circumstances were different procedurally, the First Amendment claim could have had a better chance with this, because they signed some documents that admitted violation of the honor code, or whatever it was called, code of conduct at Ball State, and that seems to put them. And I'm actually thinking this through before saying it, put them behind the 8 ball a little bit on that. And so, it had not been like that, it would have perhaps, been, less of an impediment to the First Amendment claims, because there's, there's some, and I guess it was also pretty bad that they called this guy out as a pedophile, because that that kind of puts it into the kind of speech that wouldn't necessarily be protected under the First Amendment, because of its defamatory nature. But
right.
But yeah, some always good to see some interesting facts like this in cases like this.
Not that you're sitting around your dorm. Imbibing as you might be at Ball State, not that you would run through this scenario in your mind of, gee, we want to terrorize our roommate, but we want to be able to assert that we've elevated that to an art form or, at least protectable expression. But this case does sort of alarm me that's possible. Sarah, do you foresee more circumspect terrorizing college students in the future, perhaps arguing that their public university is abridging their First Amendment rights?
Isn't that the claim of every college student that gets caught doing something that the university is violating their First Amendment rights for drinking underage, being caught drinking underage, or possession of illegal substances, and not turning their homework in on time or whatever. I think that's just everyone. The funny thing is that catfishing has probably been around since the dawn of time. And it's just with the internet, it becomes so much more prolific. I mean, it's kind of that constant bullying has been around, since, people were raping and pillaging. And now it's just, you can rape and pillage and not have people see you do it. I mean,
right. Yeah. The internet aggravates two parts of this. One, the ability to carry out this kind of scheme, and two, the ability to argue that, hey, it's expression. We wrote it down, we published it, and made it widely available.
And
so,
right.
I was going to add one thought, which is it would be interesting, or it would have been interesting to see what happened if the ex-roommate brought a civil claim and what his chances were. Here the claim was brought by the students who were the ones doing the terrorizing or harassment. But the ex-roommate who was victimized or quote unquote victimized, wonder what the result would have been if he would have asserted a civil claim and said, hey, you invaded my privacy. I don't know what other possible claims he could have brought, but I'm sure he could have cobbled together some claims.
Sure. Defamation, maybe.
True. Yeah.
Right of publicity.
Emotional
but
distress.
Yeah, tort claims. I don't know. Right of publicity, but there was, it depends on how you characterize this as a commercial use or not. But I don't know. Maybe that's the latest niche for people coming out of law school. Represent poor victimized roommates and help them pursue their legal rights. All right. Anybody care that you can get tagged on Instagram now? Let's first state the fact that we are moving on to some privacy stories. Instagram tagging, I'm surprised you couldn't do it before. Venkat?
I think I might be overreacting, but I'm not enthusiastic about it. I just hate the concept of tagging. I hate being out of control of where I might appear or where content about me may appear, especially when it comes to photos. So I'm hoping they have some setting that lets you disable it. I mean, it's not the end of the world. I don't think it's anything catastrophic, but instinctively, I don't like the idea that you can go on Instagram and see not only the pictures I've posted, but any pictures that are taken of me by other people.
Right. I think it's going to work exactly the way that Facebook works. There's a setting that if you want to be alerted and approve every time you've been tagged, you turn that on and off you go. Can't be tagged without saying, okay, that's me, and I like that picture, so tag away.
And I'm guessing brands will use it as well to tag people. And I don't know, are they going to say, here's a picture of Denise enjoying ice cream at our wonderful store? Isn't it so great? Will they have that ability to do that?
Well, it sounds like the flip side of that will certainly work. That when you're out with your friends and you tag not just them, but the establishment. You're going to be able to tag the commercial entities page. And then they'll, it will appear in their stream. And, presumably they will turn on the function of being able to approve or discount tags of them as well. Because if they don't, it could get pretty funny. But yeah, then they'll have not only their photos, but user-generated photos of people having a good time at their restaurant or what have you. Evan, any thoughts on this?
No, I mean, they ought to know a few things about the technology, how to do it. So, it comes as no surprise to me.
Yep. All right. Was it Cash Hill who decided she was going to live via Bitcoin?
Yes.
Yes. I haven't read through this yet, but I think Venkat and maybe Evan have. How'd that go for Cash?
Venkat?
I was going to defer to you, but I will say that one thing that is really, really interesting is seeing the feedback she's gotten on Twitter to her posts. She did day one and she posted it, and then she got a bunch of people who are like, here's where you can get pizza, here's where you can get coffee, or there's intermediary transactions where I guess you can exchange for cash and people can buy stuff for you. I think it was somewhat challenging, particularly on the food availability of food side and maybe transportation, but all in all, a very, very interesting experiment, and it's been fun to read.
So what's the privacy angle?
The privacy angle is that I think a point where you almost always lose anonymity online is when you buy stuff. I don't know exactly how PayPal works, but certainly when you use your credit card, whoever you're buying from knows who you are. And I sat through a couple of weeks ago this trial involving this actress and IMDb, not to digress into that, but the reason why or how IMDb knew the true identity of this actress who took pains to conceal, to use a stage name and conceal her birth date, is that she paid for a pro subscription, and with that she had to submit her credit card info, and that was her real name that came along with that. So I think if you pay using credit card, you're definitely leaving tracks, and with PayPal, I would assume you are as well. Bitcoin supposedly is a way to spend without being tracked at all, or at least that's how it is in theory.
Mm-hmm. So, Evan, we're still talking about Bitcoin. It's still out there. Cashfield's living on it now.
Right, and she said she's she's going to write a book about the Bitcoin diet because of how difficult it is to live on it. Well, I saw she and Mike Masnick were having a conversation on Twitter about that this morning. So, I'll go ahead and own up to it. I won't try to bury it in the obscurity of time. In 2011, I said Bitcoin wouldn't be a big deal a year from then. And, here it is 2 years later, and we're still talking about it. That, I will observe still a very small fraction of society at large that even knows what it is. I just think at the end of the day, the whole concept of a currency unsupported by the sovereignty and the weight of a government is not going to, be able to sustain societies. So I think in certain niche markets and, for a limited set of transactions and for as long as we are, peaceful in society with these types of things, it may work on the periphery, but I still don't think it'll ever see that anything with that sort of infrastructure will support large economies. I just don't see it.
What do you think, Sarah, as a solo practitioner, small business person? It seems like there's some appeal to this form of currency. Do you agree?
I think there is an appeal. I mean, in some ways, it's digital bartering, and if you both accept this type of currency and it's meaningful to both parties, then it works. The question is, what do you then do with this thing that you get? I mean, can I actually go do something with it? I can't pay my mortgage with it, or my phone bill or anything like that. But could I get something of value in exchange for that? This is kind of the digitization of the guy who started with a paperclip and converted it into like $1 million or some random thing. He just kept trading up. Yes. Type of thing. So, I mean, the thing is that, you couldn't then put anything on Craigslist because then Craigslist would own it, getting back in full circle from where we began. You couldn't tell people on Craigslist that you're doing this and try to get them to give you stuff. But I think it's digital bartering. And the only way bartering works is if everybody involved in the transaction has something of value that they see as valuable. And if I could then parlay it into something as valuable or more valuable, I think as a solo practitioner, it might be valuable to me to do that. But I think Evan kind of has the door open for this to just keep scooting on out. That what happens when you end up holding a big old bag of Bitcoin?
Yeah. I don't know. It's been fascinating to watch its value fluctuate.
And one point to add is that, the people who seem most interested in Bitcoin are like journalists, really. It's like, it seems like there's constant discussion of Bitcoin, but the only people other than who are involved in Bitcoin who really talk about it are journalists. I mean, it's kind of an interesting discussion, but I wonder if the influence of Bitcoin is just kind of overstated through that effect. And
it's not immune from being stamped out of existence by the government. I mean, the government interest in minting currency is extremely important because, it's through the government influence on the economy and the treasury and all that stuff that a lot of civil order is maintained. As much as, you Ron Paul fans out there may not like it, that's just the way that modern societies are architected. And, I think that Congress or even a state, the state legislatures could enact a statute that says, and I think I said this 2 years ago when we were talking about it, and it could still happen at any time, especially when the government sees a real threat to its monetary system because of some unsubstantiated framework like Bitcoin, that it could enact a statute that says, no liability shall lie for breach of contract in any transaction in which the basis of the consideration was some artificial currency like this. And so what you have then is transactions happening where if one party breaches, you don't have a remedy at law. You can't go to court and sue somebody for the car that they failed to deliver to you when you paid them a zillion Bitcoins for it. And so people are going to start losing faith in that subset of the economic system like that. And then it'll, even more quickly move into oblivion at that point if the government chooses to enact legislation to accomplish just that.
And one last point I'll add, I meant to send this around, this link, but there was a lawsuit filed yesterday between somebody who said they have an exclusive license with Mt. Gox. I'm not sure if I'm pronouncing that correctly, one of the big Bitcoin exchanges to service the U.S. market. I didn't read it closely, but and I'm curious about the effect of something like that. I mean, these are two relative big players in the Bitcoin space, and to the extent they're squabbling, I wonder if people are going to look at that and say, well, what does that mean for the overall lasting nature of Bitcoin?
Venkat, are you confident that the privacy protecting aspects of using the currency would remain in place? I mean, just because you're not using a credit card number, you still have an account and are making transactions that are being tracked somewhere, don't you?
That's a good point. Yes, I think that has probably not been tested. The privacy protecting aspects of Bitcoin probably takes a lot of effort on the part of the end user to make sure they're truly private, and I think it's probably a challenge. And then also, I expect the government also might come along and say, well, for certain types of transactions, we want tracking, and try to force people who are dealing in Bitcoin to say, we need some reporting above a certain point. So I don't have a ton of confidence. I haven't looked at it super closely, but I don't have a ton of confidence that Bitcoin is some sort of solution to the privacy problem presented by credit cards and payment.
All right, well, we're winding toward the end of the show. Before we wrap up, why don't we do a bit of planes, trains, and automobiles? Transportationally oriented stories. Following up on our discussion of Planesploit last week, this was at the Hack in the Bot conference, where it was demonstrated that Hugo, I'm forgetting his last name now, had developed an application with his Android phone that could potentially control aircraft avionics. We were discussing, at some point we just said, well, pilots need to just look out the window and make sure that, double check that their instruments are telling them the truth. And listener Abby Beckert wrote in to very correctly say that if a plane is hacked and instruments are taken over, they can't just look out the window in bad weather or at night. They can't see anything but black clouds above a black ocean below. And also because the cabin is pressurized and big planes can move so gently, you might be nose diving 10 or 20 degrees and not even feel anything until you hit the water at 700 miles per hour. The latest passenger jet, he says, even uses computer networking instead of physical cables and hydraulics for controlling the wing flaps to reduce weight and improve fuel economy. So a hacker could conceivably crash a plane and kill everyone on board. So yeah, this is something to pay attention to and fix. And I'm sure that the various aviation authorities are doing just that. But we wanted to give props to Abby for his comments. Let's talk now. Let's talk first. We've discussed some terms of service issues already today. The terms of service for the initial release of Google Glass have gotten some attention because they include this anti-resale provision. Now, a huge caveat on this, Google Glass is not freely and publicly available. Google selected 8,000 people to be able to purchase Google Glass for $1,500 a piece. And I believe that the terms that we're talking about are only applying to that test group. But for that test group, they are not allowed under the terms of service. They are contractually barred from reselling the glass that they've purchased, which is a little strange. And I'm thinking it will likely change down the road, so that when you're done with Google Glass, I know we're all so excited to try it out at this point, but there will come a day when, you need to upgrade to the next version of Google Glass or some such thing, and you want to resell your old one and send it off to someone like Gazelle. And hopefully you will be contractually able to do that. But this definitely stirred up a bit of concern in how could Google tell you what you can and cannot do with the hardware you've purchased. Venkat, is this a tempest in a teapot? Or are they just trying to control this small test audience?
I think that's a good question. I think that I would assume they would be able to do so through the software. I don't know. I'm struggling with this one. I'm hoping they do just implement it for a test audience. I would think the user reaction might be somewhat negative if people find out you can't really transfer Google Glass. And I haven't really thought through how they might implement it outside of a contractual provision. I mean, if there's a contractual provision that says you can buy this car, but you can't resell it. I mean, there must be some legal doctrine that says you can't do that, right? Evan?
Yeah, there must be. What do you think, Evan?
This is all a big deal about nothing. We've glossed over the fact that Google's terms say you can't engage in commercial resale of these things. I read that as allowing, if you want to sell it to your friend, go ahead and sell it to your friend, because there's a distinction between, commercial type of transactions and, personal or consumer level transactions. So I don't think the Google terms prohibit at all the kind of resale that 99% of us would be contemplating in this thing. There's this, there's such a hair trigger on outrage for this kind of stuff. It's like, oh yeah, I can't unlock my cell phone, so the world is ending.
But something like Gazelle is commercial. Right, and that's what a lot of people.
From Gazelle's perspective, I'm not engaged in a commercial resale if I'm just selling something on Gazelle. At least that's what I would argue. I'm just selling my stuff. It's the same thing as selling it at a garage sale. If I have a garage sale.
I think it's unclear. I agree with you. Sorry to interrupt. I agree with you that people's sensitivity seems somewhat heightened. But I think I don't really know what commercial resale means. Are they saying, if it's a one-off sale, it's okay? Or, if I sell a bunch of stuff on eBay on a regular basis and I happen to sell my Google Glass, does that mean it's okay? Or I don't know that it's easy totally to say what the line is.
Yeah, I think that would be totally fine. That's how I read the Google terms here. And, so that's the starting point that I come from all this. I think that this is just another opportunity for some hand wringing here on these sentiments. That's the same part of the brain that gets people upset about not being able to unlock your cell phones. That expiration of that exception for anti-circumvention liability that expired under the DMCA. Section 1201 there. But, okay, and with that said, there's plenty of situations in reality where in the commercial marketplace, one is barred from reselling products. There are all kinds of distributorship agreements where a manufacturer will place restrictions on its distributors, and those are enforceable. And they exist even though we have the exhaustion doctrine or the first sale doctrine. As long as they pass trust. What was that? That body of law.
Yeah, that's.
Considerations.
I do think antitrust considerations might come into play here, although we're really in sort of a consumer protection arena. Sarah, do you have any thoughts about laws that would prevent Google? Let's say it's not just for the test group. Let's say that Google has decided that Google Glass is such a unique product that, yes, as someone asked in IRC, you can gift it to someone else once you're done with yours, or you just want to give it as a gift. But you can't resell it. Do you think that another law would come into play here and say, sorry, Google, it doesn't work that way?
I don't know if there's another law, but this is where we find transactional lawyers and litigators hate each other. Because the litigators say the transactional lawyer didn't do as good a job in writing the terms of service. The thing is we see the prohibition on commercial resale or even personal resale sometimes in the distribution of movies to members of the Academy and the media and various things like that, books, preview series and things like that. So we do see these, but again, it's usually contractual. And the argument that, terms of service is a contract, regardless of whether or not you have read it or you have the ability to negotiate it in a fair deal, there could be problems, but we get to look at the nuanced words with Evan, the commercial aspect of it. And, what is a sale? And, then you do look at places like Gazelle. Your transaction with Gazelle may not be commercial, but what's Gazelle going to do with them? So if they can't resell them,
I think it's commercial. They're paying me for my old junk.
Right.
But you're not in the business of
you're
doing
not in the
that.
business of, right.
Yeah. I guess.
Right.
And I mean, if the word commercial didn't have a special meaning, that whomever Google's smart lawyers were that drafted this wouldn't have put it in there. They would have just said you can't engage in any resale. They wouldn't have they wouldn't have carved out a subset of prohibited conduct. That adjective means something. It doesn't it's not just superfluous.
I'm interested to know.
Surplusage. Let's make surplusage our second MCLE passphrase for this.
It'll keep you regular.
Of This Week in Law. Because how often do you really get to talk about surplusage, but
Has
something we
everybody
all
seen-
remember from contract law?
Has everybody seen white men wearing Google Glass? I assume you have. I hope you have.
I have heard of it and have been meaning to pull it up to entertain myself, but have not seen it yet.
Yes, it's a fun Tumblr. That is what it sounds like.
Okay. Well, that's why I put it under the planes, trains, and automobiles kind of heading, because the eSurance blog, this is an auto insurance company, took on the question of whether Google Glass might be a benefit to drivers. And I'm sure auto insurance companies and auto companies themselves are very interested in, what makes their vehicles safer and everybody's driving experience better. Unfortunately, although they put forth an analysis how Google Glass might lessen distractions in driving, that when it comes down to it, though, they identify 3 types of distraction that you're subject to when you're driving along. Visual, what your eyes are doing at the time. Manual, where your hands are. And cognitive, that's the big kicker, the cognitive one. How close to reality or up in the clouds your mind is. And unfortunately, Google Glass fails the latter one. You can have hands-free and your eyes right where they would be, but if you're paying attention to information funneled to you from glass, you might be terribly distracted despite that. So
To me,
unfortunately,
it sounds like terribly impractical. Are you really you're wearing glasses and then you're seeing stuff on your screen in your glasses? Is that what the idea is?
It's like a
it's
little
just
piece of glass.
above your line of sight.
That
It is
sounds
not
terrible.
all over, your field of vision.
It sounds beyond distracting and something that doesn't really solve the I have to look at my cell phone issue, and it just puts you in this weird position where you're half distracted, but I'm not sure you're really gaining much by having the screen like up next to your eyes. I'm a huge skeptic.
All right.
Mm-hmm.
Well, we'll know once people start being able to resell their glass, because I'm not going to plunk down $1,500 for them. I don't think you even can at this point. The 8,000 have gotten their glass and scooped them up.
8,000 glass holes out there.
Yes. Yep. Robert Scoble actually has a magazine on Flipboard called Glass Holes, where he's aggregating everything related to Google Glass. It's very informative. So if you're interested in the technology, let Robert be your guide, because he's putting everything together over there. And then the Siri manufacturer also took issue with the Siri designer, I guess I should say, took issue with an article claiming that Siri made you very distracted when driving, because apparently in running this test, they didn't test it in driving mode. Siri has a whole driving mode you can use when it's connected to a hands-free or wired headset that vastly limits what you can do with Siri. It will make you, have to spell things out and check things through the audio as opposed to looking at the screen. Much like my car does. I drive a Ford with Ford Sync and my Ford Touch, and there are certain functionalities that you just can't do when you're driving. You're over there trying to poke at the thing, and it'll say, "Nope, sorry, you're driving. You can't do that." So, the Siri. Let's see. His name is Adam Shire. He's the co-inventor of Siri, and said, if you're going to do a study about our technology and driving, put it into driving mode first before you go ahead and test it. So I think on a state-by-state basis, though, it's interesting, whether how states are going to come down on this. If you've got Siri plugged in and you're using it while you're driving, or you've got Google Glass showing you driving directions, I don't know how the states are going to parse that, whether it's part of their hands-free laws or not. What do you think, Evan?
I don't know. I'm reluctant to even start talking about this, because you're talking about visual distractions, hands-free, cognitive stuff. I don't know. I'm afraid I'll make some jokes that I'll regret on all about this here. So, it's all. I mean, I imagine that as technologies continue to converge here, and we get closer to crossing over that brain device interface where like there's actual computing going on in the brain, and then as sensory input becomes closer to us there, that all these questions are probably going to the nature of the questions are going to change, because first of all, how are you going to enforce something like that if I'm just able to have augmented reality just by thinking or doing something because of the computer interfaces that are implanted in my skull? I don't know how we can really start setting down reasonable regulations here that are going to stand the test of time. So hopefully that was sophisticated. There was enough sophistry in that answer to show that I didn't have a good answer to your question.
Brilliantly done, yes. All right, I think with that, we should move on to our tip and resource of the week. I have one actual tip and one more humorous one at the urging of the panel here that we put this in the tip section. I'll start with the more serious one. Over at Business Insider, there is a detailed report on a company called Mandiant, who did a security analysis of Chinese hacking, and the Chinese army actively engaged in corporate espionage, trying to get information from not other governments, but big companies like Lockheed Martin and various others. It's a really fascinating report that that Mandiant did, and that is well summarized over at Business Insider. The tip would be, if you're working away and you get an email from a coworker that says, let's schedule a time to meet, we need to finalize the press release, and then there's a link to click. No, don't do that. That's the Chinese army putting a backdoor into your system. Of course, that will change. So now that this is all public, so just, be on the lookout for strange looking emails from colleagues, because the idea is, I guess, as China tries to compete globally, that this is a government sanctioned, well, again, China denies the report. The Mandiant seems very detailed in its information here, so you can make your own mind up about what is and isn't going on. But the theory is that in order to compete, getting information from companies like Lockheed Martin would be beneficial. Apparently that already happened. And there were some jets that the Chinese made that were very similar to a model that Lockheed had in progress. So it's interesting stuff. And I encourage people to just look through it and to pay attention to your coworkers' emails, and always have your guard up as to whether that really is something that you're working on together or not. And then our funny tip comes my way courtesy of Doc Searles on the VRM mailing list, who sent around a tip from Chase Bank via The Onion that is a security tip, something that you need to do in order to make sure that your online banking information is truly secure. They're encouraging you not only to log out of the tab, log out of your browser, then charter a seafaring vessel to take you 30 miles out into the open ocean and throw your computer overboard. Various other steps that you should take with your technology once you've finished your online banking. Using a smartphone or a tablet, very similar process, but you demolish the device, you find the nearest canyon, you scatter the remnants, bury them over various 100-mile radius, and then you're good to go. What's particularly funny about this article, I think, the notion that you can never be secure, and that perhaps just demolishing your device would be the response. I don't think that would make you any more secure if you demolished your device. The information has already changed hands and passed. And what do you think, Venkat? Could this do any good?
I agree with you. It doesn't sound terribly effective, but I think the extremeness of the tip kind of is enough to serve as a cautionary tale for people who are into that sort of thing. So I thought it was funny in that respect.
It is really well done. You should head over to The Onion and check it out. We have several good resources this week. First and foremost, I alluded to at the top of the show, Sarah's blog law series has covered a bunch of really good topical issues, not just for bloggers, but for a lot of different sorts of people doing business online. Anybody who's using social media to promote their business or brand, great information there about running promotions, keeping your copyright P's and Q's in order on things like Pinterest. How did you get involved in writing all this up, Sarah?
I was just asked. I mean, the funny thing is, you tell people you're a lawyer, and they immediately think that they should start asking you questions about stuff. And the other thing is that people who are not lawyers, who feel the need to tell people what the law is, often don't have it correct. And I figured instead of trying to fix the misinformation, I would just put the correct information out there. And a lot of bloggers, a lot of men and women who get into blogging don't necessarily have the background. And the only way that we could raise the bar as bloggers is to have the correct information out there. So it's like my pro bono work.
It's great. It's very concise and yet very thorough. So I encourage folks to go check out Saving for Someday. If you Google that and blog law, I'm sure you will get right to her category archives where the whole blog law series is available. EFF has an interesting resource for folks out there. It's Who Has Your Back graph. Which companies help protect your data the best from the government. Google gets a pretty good scorecard. I think you could get up to 6 stars, and Google has 5. Verizon has 0 on the other end of the spectrum. And Twitter actually has 5. And the various criteria that EFF is using here, requiring a warrant for content, telling users about government data requests, publishing transparency reports, publishing law enforcement guidelines, fighting for users' privacy rights in court, and fighting for users' privacy rights in Congress. So you can read through that and see how they selected what companies to include and how they evaluated all of the various factors. It's some interesting information. Some other interesting information is being crunched by Stephen Wolfram of Wolfram Alpha. Evan, you want to tell us about that?
Yeah, just this really long blog post that he put out last week that does some really interesting discussion about trends on Facebook and predilections of the different users. It's a very in-depth post, and of course, he has tons of data, and it's really getting to the point where we can start looking at Facebook and the social networking science behind it now in a more detailed level. Now that people have been on Facebook for several years, we've got several years of data to look at. The thing that I found most interesting was toward the end of that blog post that talked about the different ways that one's interests evolve over one's lifetime. Of course, the easy examples are of how people in their 20s post and discuss more information on Facebook about college and education. Younger people talk about fashion more. As you get older, you become less interested in fashion. Interest in sports kind of stays constant throughout a man's life, whereas a woman's interest in sports is less. And you can imagine all kinds of other extrapolations that you could make from all this. Interestingly, more interest in movies as one gets along later in life. So just really interesting to see empirical data stand for a lot of the things that we know intuitively about the interest that one has throughout one's lifetime. But that's just one example of the ways in which these Facebook data have been evaluated and looked at. There's a lot of interesting social networking phenomena that are scientifically supported in that report. So interesting reading.
Yeah, it was really fascinating, and also the fact that I didn't even realize that there is this tool from Wolfram Alpha that will show you some very granular information about your own network on Facebook if you choose to link it up and let it crunch your own personal account. Evan, is that how they're gathering all the data that is included in the study? I wasn't too clear on that, of whether they had a separate group of volunteers that were providing the data, or if any time you do the analysis, you're now part of their data set.
Yeah, I'm not quite clear on that either, because it's a huge data set. So I don't know. I have to go back and study that point.
Yeah, interesting. Okay, well, thanks so much for putting that in front of us. That was some really fascinating views into society and life. All right, so with that, I think we will go ahead and wrap up this episode of This Week in Law. It's been very fun chatting with you all. We've had a very feline sort of show today. Always a good time. Venkat, great chatting with you as always. What are you up to these days?
Just the usual. The springtime is good weather in Seattle, and it's been really nice here. So hopefully stepping away from the computer and enjoying some outdoor activities.
Good. I hope you've been having some really nice weather in Seattle, haven't you?
We have. Yep. It's been great.
Well, enjoy it. Toiling in the vineyards of justice, as one of my law partners always used to say.
That's awesome.
So just keep on toiling. Sarah, great meeting you. Thanks so much for joining us today.
Thank you. Thanks for having me.
It's been a pleasure. And folks, you truly need to go check out Saving for Sunday someday, not only for the great legal analyses over there, but the wonderful tips on saving a coin or two here and there, a Bitcoin or two, perhaps. So really great work, Sarah. Thanks so much for joining us today.
Thanks, Denise. Thanks, Evan.
Yeah,
Evan,
sure.
wonderful chatting with you, as always.
Yes, great time. Lots of interesting stuff. Sarah, very nice to meet you and talk with you. And Venkat, the same. Always good to talk and great to catch up. And lots of interesting topics. And really enjoyed it today. So it's been really good to be here.
Great.
It has been really good. And if you want to join us, we do this show every week. We do it at 11 o'clock Pacific time, 1800 UTC, live on the TWiT network, which you can find at twit.tv. But if that scheduling doesn't work for you, you can always catch us after the fact. We're on YouTube. You can go to twit.tv/twill, and the entire archive of shows is there. We're in iTunes, and however you like to listen to time-shifted podcast, netcast entertainment. We're going to be there for you. So we just are so thrilled that you've joined us today, and hopefully we'll do so for more episodes of This Week in Law. If you do go onto the iTunes site to find the show, we'd love it if you drop a review in there for us. It's always informational and great for us to see. We'd love to get your opinions and feedback in all sorts of places. We have a Facebook page for the show, a Google Plus. Actually, we have a Google Plus page for the show, but I probably put more information on my personal Google Plus about the show. So that's a great way to reach me over there. Evan and I are both on Twitter. I'm Dee Howell there. He is Internet Cases there. And we love hearing your ideas about stuff we should talk about, follow-ups on things that we have discussed already, and things like what Chase thinks you should do to keep your data safe. We love a good laugh too. So keep them coming, and we'll do the same with the shows. And we'll see you next week on This Week in Law. Take care.